All right, good afternoon, all you fellow quarantining Houstonians. We're gonna do something a little bit different today. We're gonna have our very first Zoom event, and today I am very grateful for Professor Blackman for setting this up for us. Thank you, and we appreciate your technological expertise here. And I would like to introduce our speaker, Dan Hinde.
Criminal cases. But then we had the H1N1 outbreak about 10 years ago. And I was about to go on the ancillary duty as as the judge that handles TROs for half a month. And one of our senior judges called me and said, it's not really in our rules, but there are some certain motions dealing with people with infectious diseases that when they're filed, they go before ancillary. We know you have young kids, so if you'd rather not take those when you're on ancillary, just give me a call. And that judge said that she would take any of those that came through. None came in, but I was intrigued by it. I went to find the statute that governs those. I looked at our local rules, and I started thinking about it. And got some of the other judges to think about it. And over the years, we kind of refined our local rules to make it clear what would go on. And then one day, I had one of them filed in my court. And I believe it was at the time that I was on ancillary, so I was going to handle the preliminary motions as well as the final matter. And I discovered these are extremely rare cases. In fact, I think I had the only one, as far as I can tell, that was filed that went anywhere in the 10 years that I was on the bench. And so, as we were getting ready for trial on it, we ended up having to take a lot of measures and do a lot of preparation to get ready for it. They require a lot of work and attention, especially since they are so unique and we don't have regular practice for it. And so I gained a lot of insight on them. I thought before I got into that specific case, though, we kind of look at some background to see something about where these come from and why they are they're unique and why the courts might have a role in it. So I've got a little slideshow here that I'm trying to get going here. So I titled this "The Court's."
And Dan, if I could just briefly interrupt, the best way to view slideshows on Zoom is what's called side by side. So the top of your screen, you'll see you are viewing Dan Hinde's screen in green, and next to it says View Options. Click View Options, and then go side by side mode, and then that's the best way because you'll see both Dan and the PowerPoint. And you can actually adjust the size of the video and the size of the PowerPoint by moving that a little gray bar from left to right. So again, do side by side mode, and it's a lot easier. I'll shut up now.
No, but I don't have that bar that you're talking about.
You won't have it. Only the viewers have it.
Okay. All right. So with that clarification. As we're all learning a lot of new technology as we try to work from home, prepared a short slideshow to come through some of the background here. I called this "The Court's Role at the Apex of State Power, Public Health Restrictions in the Time of Pandemics." And the way to think about it, first of all, is what are we talking about when we talk about these public health restrictions? Usually we talk about quarantines. Little bit of background on quarantines. They were originally created in a town called Rusa, which is now in modern-day Croatia. It's now known as Dubrovnik, but at the time it was part of the Venetian Republic. And this was the time of the Black Plague when it first started hitting Europe. And so what the Ragusans would do is any ships that were coming in from ports where there had been plague were held offshore at Trentino for 30 days to see whether they had plague on board. Eventually, they extended the Trentino to a Quarantino, which is short for Quaranta Giorni, which is Italian for 40 days. They would hold the ship offshore for 40 days to see if they had any any infestation on the ship. Got shortened to quarantine. The concept went viral to the rest of Europe, first to the other cities in the Italian peninsula, and then elsewhere in Europe, and became a standard public health tool in times of epidemics. Now, why did they pick 40 days? I'm not really sure. They think it was probably a reference to some biblical passages, such as when Noah was on the ark for 40 days and 40 nights, or Moses was on Mount Sinai for 30 days, or Jesus spending 40 days in the wilderness. It's also may not be a coincidence that it's the same period of time from Ash Wednesday to Easter, the period of Lent. So that's kind of where we think the idea of 40 days came along. But the concept of isolating people who have been to disease-affected areas during the incubation period to determine whether any of them have the disease goes back to that concept, the quarantine. Now, I call this the apex of state power because we're really talking about a measure for health. And we always talk about the police power, which was reserved by the states as being the power to regulate health, safe welfare. You go back over 100 years to a case that was about the police power that dealt with, in that case, a mandatory vaccination program. Massachusetts had passed a law requiring adults to get vaccinated against smallpox, and Mr. Jacobson defied it. He was prosecuted, fined, I think, $25, and challenged his conviction, went up to the Supreme Court, and the first Justice Harlan wrote for the majority, a 7-2 decision. I've got a snippet here, but the longer passage is the authority of the state to enact this statute is to be referred to what is commonly called the police power, the power which the state did not surrender when becoming a member of the Union under the Constitution. Although this court has refrained from any attempt to define the limits of that power, yet it has distinctly recognized the authority of a state to enact quarantine laws and health laws of every description. Indeed, all laws that relate to matters completely within its territory and which do not by their necessary operation affect the people of other states. So, according to settled principles, the police power of a state must be held to embrace at least such reasonable regulations established directly by legislative enactment as will protect the public health and the public safety. And so, and it went on to say that a community has the right to protect itself against an epidemic of disease which threatens the safety of its members. So, the police power has been held for over 100 years to embrace these kind of health restrictions. Now, we're not used to seeing this kind of thing, but it was a lot more common in the 19th century when states, cities all over the country were dealing with epidemics of cholera, influenza, measles, scarlet fever, smallpox, typhus, and yellow fever. And they often impose different types of measures such as quarantines, isolation orders, and mandatory vaccinations. And we can look, I did a little research just locally in our neck of the woods. Houston, between 1839 and 1867, had 11 yellow fever outbreaks. One in 1839, 12% of the population died, and in 1867, about 7% died. You can look, I found, I promise it's a coincidence, not just because I went there, but Bryan, Texas, I found a whole host of all kinds of news items out of there where they were quarantining refugees, they were requiring mandatory smallpox vaccinations. In 1897, they imposed quarantines against trains stopping from New Orleans and Beaumont after yellow fever outbreaks there. In 1908, the president of the A&M College of Texas quarantined a professor's home after a case of whooping cough had been discovered there. So that's back in the 19th century and early 20th century. It was very common to have these public health measures when epidemics were raced through the local population. Well, let's talk about how it's set up in modern times. And really, you look to the modern system was set up in 1975 when Texas passed the Texas Disaster Act of 1975. And it set up this and another statute we're going to talk about, Chapter 81 of the Health and Safety Code, set up a set of executive actions that could be taken in order to address public health emergencies. So you've got a disaster declaration by the governor. The commissioner of the Department of Health can declare a public health disaster. And then under Chapter 81, public health authorities, there's a statewide public health authority, and then municipalities and counties can have their own public health authorities, can enact control measures for both individuals and small groups. And then they can also impose area quarantines. Now, the various control measures that are authorized by the statute include things like immunization, detention, restriction, disinfection, decontamination, isolation, quarantine, disinfectation, chemoprophylaxis, preventive therapy, prevention, and even just education. Those are the statutory measures that public health authorities can impose. And a public health authority is imposed by the local government, or is appointed by the local government. They have to be a physician. So you have to have a doctor be the public health authority, but then they have the authority to impose some of these control measures. So, we've talked about the public health disaster, individual control measures, and the individual control measures. It's a pretty easy standard to achieve. A public health authority or the Department of Health and Human Services can impose an individual control measure if they have a reasonable cause to believe that an individual is ill with, has been exposed to, or is the carrier of a communicable disease. They can also impose that on groups. If there are 5 or more people, they can impose it on a group of 5 or more people. The public control order just has to be in writing, and it can be served either personally or by certified or registered mail. And if you don't comply with those public health measures, then the courts come into play on the public health measures. Before we get to that, I want to talk about the area quarantines. If an outbreak of communicable disease occurs in this state, the commissioner or one or more health authorities may impose an area quarantine coextensive with the area affected. So it also authorizes quarantines. Now, on those executive actions, the quarantines and the health disasters, the court's role is really to try criminal prosecutions. It's a Class B misdemeanor to knowingly conceal or attempt to conceal exposure to or carrying a communicable disease during an investigation by the Department of Health and Human Services, a health authority, or even a peace officer. It's also a Class B misdemeanor to knowingly refuse to perform or to allow performance of health authority control measures. So if you interfere with a control measure for someone else, it's a Class B misdemeanor. It's a 3rd-degree felony to knowingly fail or refuse to obey an area quarantine. So that gets them to, a 3rd-degree felony is punishable by 2 to 10 years in prison and up to $10,000 fine. So in those situations, there is the role is to try the criminal prosecution. But they also have the role of what to do when people will not obey a public health control measure that has been sent to them. If you've got someone with a communicable disease or is reasonably suspected of having a communicable disease, what can we do to make them comply with the control order? And that's where the court's role comes into play that I was involved in. When you have basically a non-compliant person with a communicable disease. And this is governed by Chapter 81, Subchapter G, I believe it is, of the Health and Safety Code, where a health authority can go to a court for an order for the management of a person with a communicable disease. It generally arises in situations where a person is infected or reasonably suspected of being infected with a communicable disease presenting a threat to public health, and the person is not complying with an order from a public health authority. And so the way I think order for management. There are two types of management. There's temporary management, which is not longer than 90 days, and extended management, which is longer than 90 days. And you might think, in the context of what we're dealing with, why are we going to need anyone to be managed for more than 90 days? There are some infectious diseases out there that spread for a long time before they become debilitating to the host. And the most common one is tuberculosis. And so, you have to be on your meds for like a year before you're basically out of the woods on tuberculosis. And so in that situation, they usually ask for an order for extended management if someone's not complying. A couple of interesting things we'll talk about here with the application for an order for management. The trial has to be held within 14 days of the filing of the application. Normally, the rules, you can't be called to trial at least 45 days after a petition is filed. But in these things, it has to be held within 14 days. The court can grant extensions, continuances, but the longest continuance they can grant is no more than 30 days from the filing of the application. So even if you grant extensions, it has to be tried within 30 days. The location, it has to be the statute says any suitable location in the county in a physical setting that is not likely to have a harmful effect on the public or the person. But the respondent can request that the hearing be held at a courthouse, in which case it has to be held at a courthouse, which is kind of contrary. Most of our courthouses really aren't set up to avoid spreading communicable diseases. The respondent is entitled to be present at the hearing unless the health authority advises the court that the person must remain in isolation. But if the health authority doesn't give that advice to the court, then this person with a communicable disease has right to appear at the hearing. It's in open court unless the respondent requests a closed hearing and there is good cause to close the hearing. So if you feel like you need to close the courtroom to prevent spreading it outside the courtroom, it's got to be the respondent that asks for it. The respondent can remain at liberty pending the trial unless the government gets one of these interim orders we're going to talk about. The burden of proof on these applications is clear and convincing evidence. However, there is a statutory provision that the court can rely solely on an affidavit of medical evaluation as long as that is clear and convincing. That's legally sufficient evidence. Now, the one that I think surprises people the most is the respondent has a right to a jury trial for one of these applications. If it's an order for temporary management, meaning less than 30 days, they have the right to the jury trial if the respondent requests a jury. If it's an order for extended management, they have a right to a jury trial unless the respondent affirmatively waives a jury. So that brings in the question of the right to trial by jury. The two issues that the jury has to answer is if the person is infected with or is reasonably suspected of being infected with a communicable disease that presents a threat to public health, And if you're asking for inpatient treatment, the person has refused to or failed to follow the orders of a health authority. So it's in essence, you have a right to a jury trial within 30 days on one of these communicable disease cases. Now, there are some, as I mentioned earlier, some preliminary motions and orders. When you've got someone who's got a communicable disease and they refuse to self-isolate or social distance, then the government can come in and ask for an order for protective custody. And they can even do an order for temporary protective custody before they've even filed the application. And these are the kinds of things that would come in front of the TRO judge in Harris County. And there are provisions for probable cause hearings in the case of some of these protective custodies. But it's interesting, they thought of a lot of stuff in terms of procedural rights when they were putting the statute together to make sure, since we're talking about restricting someone's liberty, making sure we're adhering to due process and constitutional concerns. But there's still a lot of tricky issues that you have to think about. And, I came to a realization of this when I had my case. How do you balance the right of a fair trial and the public health, for instance? In criminal cases, when you have a trial in front of a jury, the defendant can't be forced to attend trial in the prison jumpsuit and shackled unless they've done things to disrupt the court proceedings. Well, if you hold one of these trials and you're handing out face masks to the jurors, or you're requiring the respondent to wear a face mask, are you there by prejudicing that person's right to a fair trial, since one of the questions that the jury has to answer is whether they're infected or not? So you've got that kind of a question. What do you do when they insist on having the trial in the courthouse? How do you bring them into the courthouse without exposing others to a potential infectious disease? Which elevator to use? Which courtroom to use? Are you going to have to take measures to restrict access to the courthouse, or measures as people are leaving the courtroom in terms of testing them and disinfecting? And you got to balance all of that with not prejudicing the jury, nudging them to think, okay, this person is infected just by the way everyone's treating them. And then you got to think about the rights of the court staff who are there, they have to work. When I had my case, my court reporter came to me and was very worried, because if the respondent was going to testify from the witness stand, the court reporter's downwind from the witness, and she didn't want to be exposed to TB, and she had a perfect right to express that to me. And those are things you have to think about, not just what the statute tells you, but, for instance, where are you going to put the respondent in the courtroom to make sure that you're not prejudicing his or her right to a fair trial, but also taking reasonable measures not to create a dangerous work environment for your employees, or not exposing the public to an infectious disease. So those are a lot of things you need to think about. We've got some other motions here I pointed out that can be decided under this. Some of the interesting things, especially for our appellate folks, is there is a right of appeal for orders for the management. The appealable orders are the management of a person with a communicable disease and the renewal of them. The temporary custody orders, those are not appealable orders. So if you want to challenge them, you have to somehow mandamus. The deadline to file an appeal is 10 days. And what's really interesting is an appeal under this statute has preference over all other cases on the Court of Appeals docket. Same holds true for the Supreme Court. If there is a petition for review or an appeal to the Supreme Court, these cases take preference over everything else on those courts' dockets. The statute takes great pains to make sure that the right of habeas corpus is not infringed, so you still have a right to apply for a writ of habeas corpus. There is criminal enforcement if someone's resisting or evading detention or assisting a person in evading detention. That is a Class A misdemeanor. So, what happened in my case? She was a non-compliant TB patient who was not isolating even from her young grandchildren. So the county, or maybe it was a city, brought an action. She declined to waive her right to a jury, and she wanted the trial at a courthouse. Now, one of the things that Harris County had done, even before I took the bench, which I thought was rather interesting, is they had designated a conference room at Ben Taub Hospital as an auxiliary courthouse. And the county has the power to do this. In fact, we did this after Harvey when we lost 2 courthouses. We designated the federal courthouse and the law schools as auxiliary courthouses so that we could hold trials there. In fact, they held some capital trials, I believe, at the federal courthouse. And I held a bench trial, as Ms. Ferris knows, at South Texas College of Law. And so the county has the power to do that. So they designated Ben Taub Hospital as an auxiliary courthouse for these kinds of cases. But it's a conference room, and it's not really set up to hold a jury trial. So what do? Do you video conference this person in? We had a lot of these questions to answer. The government health authority did not provide the written advice that would have authorized me to done remote video conferencing and so forth. And so we were struggling to try and make sure that we figured out how we're going to bring her in to the courthouse, how we're going to bring her to the courtroom, where she's going to sit, and so forth. Finally, about an hour before the jury panel was going to arrive in our courtroom, she waived the right to a jury trial. And then we just basically had a bench trial where the government relied on the medical affidavit. She didn't put on any witnesses and essentially just defaulted on it. And we ended up sending her to a facility in San Antonio that's set up for these kind of cases. So that's basically what happened in mine. Like I said, it's very rare to have these come up. Most people who are subject to these control orders, if it's like flu or like COVID, I suspect a lot of them, once they become symptomatic, they're knocked out, and so they're not really going to be wanting to get out and not self-isolate. So these cases really are only going to come up a lot in cases like TB, where there's a long incubation period before it becomes debilitating to the host. But during that incubation period, they're extremely infectious and contagious. So I don't know if we're going to see many of these. If some of the public health measures go on for an extended period of time, we might start to see more and more people refusing to comply. And then you might have to start imposing some of these measures. I don't think the government officials really want to. I don't think the courts really want to. But before even we had the public health disaster, the Supreme Court had the regional presiding judges appoint 2 district judges in each of the 11 judicial regions to be on standby for any of these cases. And then I think they also appointed, 11 Court of Appeals justices to be on standby for any appeals. So the Supreme Court was on the ball, making sure that personnel were in place. Whether the logistics and the facilities are ready to go, I don't know. Harris County, I get the impression, probably is farther along in terms of planning for this, because they planned for this a long time ago, for how to handle these things, but we'll see. So we'll see how this all goes. Hopefully we won't have to have any of these cases, but the courts are there, ready to do their part in protecting the public health of the people. I think I've probably gone a little long, but I'm happy to take any questions.
Okay, this is Josh. If anyone has any questions, you can raise. There's a little button that says "Raise Hand." If you click the "Raise Hand" button, you can actually ask a question, and we'll call on you to feature Dan.
I have a question.
Okay, who's this?
I'm on phone. Is that okay?
Who is this now?
Hey, Judge, it's Bill Helfand.
Hi, Bill. How are you?
I'm well, thank you. And by the way, I appreciate the presentation, very informative, although I certainly expected it to be. I joined a little late, and you've repeatedly mentioned a statute, and I just would like to read the statute. Where is that statute?
Okay, so the Texas Disaster Act is, I believe it's Chapter 480 of the Government Code, 418 of the Government Code, but the one that really got into the meat of it is Chapter 81 of the Health and Safety Code. And that's got the public control measures, the quarantines, and then subchapter G is the part with the judicial process for getting orders essentially to detain and restrict the access of people who are under these public health control measures.
Perfect, thank you, and thanks again for the presentation.
You're welcome.
Okay, are there any other questions for Judge Hinde? I'll ask a question if no one else will. I can take the moderator's prerogative. You've probably seen the news. There are a lot of states struggling with houses of worship, and whether houses of worship can be given disbursement orders, right, to break up a funeral, break up a wedding, or break up some other religious ceremony. What's your thinking on how the police power intersects with the free exercise clause in the context of these assemblies of houses of worship?
That's a great question. I won't claim to be a free exercise or establishment law expert. I know a lot about it, but I won't claim to know nearly as much as some of the other lawyers out there. I would first, before I answered it, go back and look at what did they do in the 19th century. I mean, we haven't had an epidemic like this in a long time, but there was a time when the Constitution was still in place, as it is now, where states, local communities were dealing with epidemics rather frequently. Like I said, Houston had 11 yellow fever outbreaks between 1839 and 1867. So let's look. I mean, did those quarantines, did those isolation orders, did they apply to houses of worship? Did anyone challenge them under the First Amendment? Those are questions I think to be considered. You know, and I don't think it's. I think the people who assert First Amendment rights on that, they present some good arguments to be considered. I don't think you can dismiss them out of hand, but I also don't think that you can just confirm them out of hand too. I think that this is one of those situations where you really have to look at how did we do it in the 19th century. One of the things as I was doing my research, you know, there was a yellow fever outbreak in Philadelphia in 1793. So how did they handle the quarantine and the isolation orders there? Back then, I mean, that was just a couple of years after the Bill of Rights was ratified. They might have a much better understanding of what was meant under the First Amendment when you apply it to these public health measures. So let's go look at that, see what did they do in those 18th century situations when the First Amendment was fresh off the presses. That might help us inform to what extent the First Amendment would trump these measures, and to what extent these measures in the public health and public safety would prevail.
Thank you. If there are any other questions for Judge Hinde, you can either raise your hand or unmute your microphone. We'll be happy to hear from you.
I had one question. Thank you. That was an excellent presentation. In this particular pandemic, one of the frustrations has been a lack of testing. and so there's a perception that there are a lot more cases out there than we're actually picking up. If we were to have something in place like South Korea, where there was widespread testing that was picking up more asymptomatic cases, would you expect to see these statutes and these types of proceedings used more, or with the kind of short duration compared with tuberculosis, is that just something we're probably not going to see with this particular type of illness?
Well, there's the legal approach, the legal analysis of this, and then there's also the practical implementation. I think, we talk about the kinds of public control measures that a health authority can impose. It would probably come under either chemoprophylaxis or preventive therapy or prevention. How do you prevent it without testing? So I would suspect that they would find a statutory basis for saying we can impose mandatory testing. But then there's the practical way of how do you enforce that? I expect that if they had mandatory testing and they had the resources to actually test high volumes of people, you'd see a lot of compliance. I think a lot of people want to know. But what do you do about the non-compliant? How big of a group is that? Do you pick out high-profile people to set an example to help influence the other non-compliant to do it? Those are questions that are really more on the executive side. The court just takes the application that's brought to them. That would be more of a policy question for law enforcement and for the health authorities on how they want to implement the program to get as much voluntary compliance as possible. One of the advantages of these being so rare, it's not difficult to ramp up for a jury trial on at most 30 days notice for one person or two people. Let's say we have 1,000 in Harris County who they want to get orders for, and only 24 civil district judges. Even if they got all the district judges, well, and you got to try all of these within 30 days, and you got to get juries for them. That's 12 jurors per case. How are you going to do that? So there's some practical issues. I guess it would be the health authority's equivalent of prosecutorial discretion in deciding which cases to actually bring. That'd be my impression on it.
Thank you. Are there any more questions for Judge Hinde? Okay. Seeing none, I'd like to thank everyone for joining us. This went actually better than I expected, not just because of Dan's presentation, but the technology was fairly robust. April, would you like to send us off?
Yes, thank you again, Professor Blackman. This was a great event, and be looking in your email. We'll be sending information about a future Zoom event that we hope to host later this month. So thank you all for being here.
All right. Thank you all, and we're adjourned.
Thank you.